involved. So when there's expert level professionalism involved in something, that gives you a step above, all right? So in today, in 2013, he's still the expert, even more so. So we all are really, really blessed to have Bill Taylor here this evening to share his knowledge base with us about how we can properly protect our assets. With that being said, Bill Taylor.
I would say, don't applaud, just throw dollars. Secondly, Steve, your dollar will be on your desk when you leave. Thirdly, I need someone who has a watch on to tell me when 30 minutes have gone by. Who has a watch on?
I got you.
No, I need one person to read. Okay. When his hand goes up, I'm sitting down. I need someone else with a watch on to tell me when 15 minutes has gone by. Anybody? Okay, George. Okay, great. Reason for that is I'm going to pace myself. That's 15 minutes. 30 minutes, I'm out of here. I'm going to stay for the rest of it, then I'll stop talking. Yeah, I really, Jason, it's intimidating. Or whatever, that is. Our concern may be with an older person who has real estate, but who does not understand the difference between having real estate and having to probate it after they die versus having real estate and having it in a living trust to avoid the probate. Now, I will say that some of us here have personal experience where even if you have a living trust, it's like you've run into a thicket of a whole lot of troubles. That is, you're talking, Steve, about how 30% of an estate might get eaten up by probating and having to go through that whole probate procedure there. I would think, considering what the fees are, that it would be a small estate to be 30%. But let's just say that something can get eaten up having to go through probate, whereas if you have a living trust, you should save a lot more money. But some of us know that if you have relatives who like to argue or relatives who like to fight and don't believe it's written on a piece of paper, they will raise hell even in a trust. And you have your 30% in that too. So I want you to understand that be kind to your brothers and sisters so that when mom and dad goes on, you don't have them fighting to eat up what you got. Now, what I'd like to do is to concentrate on my little piece of paper here, and you will see on the left-hand side of the paper 2 stick figures that have $150,000 over top of their heads. That's mom and dad, or grandma and granddad, or if one of them has died, then it's that one person that has assets worth more than $150,000. In California, where we are, if you die owning assets worth $150,000 or more, then the law says you must probate those assets before you can give them to your the beneficiaries. Now, if you look in the bottom right-hand corner, you'll see the beneficiaries. I call them the crumb snatchers. These are the people who are expecting to get something from the death of somebody that they love. All right, but between them and the figures that have $150,000 over their head, there's a whole lot of stuff in between them. So, go directly underneath the stick figures that have $150,000 underneath, and you will see personal property and real property. In California, all the trinkets and all the stuff you have, those are personal property. Your rings and cars and everything else, that's personal property. Everything other than personal property in California is classified as real property. Add the fair market value, not the net value, the fair market value of whatever these assets are, add those together. If they're more than $150,000, then when that person dies, there's a probate. What is probate? Look underneath the personal and real property boxes there. It shows you that it's in court. So probate is a court procedure to make sure that the crumb snatchers, the beneficiaries on the right-hand side, get what you wanted them to get. And if you didn't write down something for them to get, then the law will designate this is how it flows, okay? But probate is the process to make sure that the beneficiaries get what they're supposed to get. Okay, that's, as Jeffrey Pete would say, period dot. That's it. Okay, the problem with probate is that it takes at least 6 months before these people can get what they're supposed to get. Why 6 months? Because 4 months is a period where creditors can put in their claims, and you cannot reduce that 4 months down. So you got 4 months built into the system on every probate where nothing can happen, there's no distributions until that 4 month period is over. And those of you who've been filing papers in court recently, and we have several attorneys here, they know that it takes a month before you can get the initial hearing, and it takes another month to get the exit hearing, getting out of it. So it's about 6 months at the very least on a probate. This is before the people, the beneficiaries, can enjoy what the deceased person wanted them to have. Okay, so that's the first thing. Second thing on probate is that, and I think it's a good thing, but I just don't see it this way, the attorney gets paid. Did I say something funny? The attorney gets paid and the executor gets paid. I'll explain the executor in a minute. But they get paid money out of the estate of the person who died. Now, once again, I didn't see a problem with that, but the beneficiaries don't seem to cotton to that very well. Now, how much would the attorney and the executor get? Mind you, the attorney and the executor get the same amount of money for the probate. Unless the attorney has to fight off these crazy brothers and sisters and things like that I was telling you about, that's extraordinary fees. It's extra money for the attorney. But let's pretend like you've done what I asked you to do and you've made nice with your brothers and sisters so that won't occur. Here's what the attorney would get. It's 4% of the first $100,000 of a probate estate, 3% of the next $100,000 of a probate estate, and 2% of whatever's left over. Okay? So for easy math, let's just pretend like the estate, that it's one little house, that grandma lived in, or granddad lived in, or something like that. One little house, and the fair market value is $300,000. Okay? So 4% of the first $100,000 is $4,000. So now we have $200,000 left to work with. 3% of the next $100,000 is $3,000. So 4 plus 3 is $7,000. And then 2% of whatever's left over, which is $100,000 in my little example, is $2,000. So that's 4 plus 3 plus 2 is $9,000. Nice payday for the lawyer. And the executor gets the same $9,000 as well. So it's $18,000 that has to be found somewhere in this estate, put a lien on the house, or whatever it takes, got to get paid. Okay? Now people say, man, it's a lot of money. What are you guys doing for that? And you find out what we did and say, well, you don't deserve that, and whatever the situation. So, people have problems with probate because of that. Now, let's talk about the executor. You'll see the little stick figure underneath next to the attorney that says executor. This is the person who either the decedent, the person who died, placed in a will, or it's called an administrator if the person who died didn't have a will, or if that person who they did designate to be the executor didn't qualify to be it. So anyone other than the person nominated by the deceased person will be called an administrator, but it's the same job. What their job is to speak to the judge about the estate. They're supposed to, and the lawyers do all this, all the work, but they're supposed to say to the judge, we've identified all the creditors, we have argued down the amount, we have calculated the total amount of the assets, and we now know how much is supposed to be given to each one of the beneficiaries after we've paid all the debts. And the judge says, is that true? That's true, Your Honor. And so at that point, if there's no one acting crazy in the courtroom, the judge will say, fine, we'll distribute the estate. And the estate can get the and the executor, and then you start paying the brothers and sisters, whoever else is left. Well, that's what the executor does, and someone has to be the executor or the administrator in every probate estate, and so that's going to get paid. Now, that person can renounce their money. They can say, oh, I don't want to get paid that, and I just want to get paid my share of, whatever my brothers and sisters get, my aliquot share. But most of so that being the case, a person like your grandmother, your grandfather, your mother, father, they might say, that's too much money going out. The whole process takes too long. I don't want to have my people wait for 6 months before they can enjoy what I want to give them. What's the alternative? Well, the alternative that has been legislated in California, and actually it's all over the country and the world, the alternative is a living trust. And the living trust is a thick stack of papers, probably about 30, 40 pages long, and it states exactly what a will would state. I want Johnny to have this, I want Sally to have that, things like that. But, wrapped around Johnny and Sally getting whatever they're supposed to get, a whole lot of legal boilerplate, they call it, that is a lot of legal language to essentially do something. And what it essentially does is this. The law has stated that if a person dies owning assets worth $150,000 or more, their estate has to be probated. All that legal boilerplate does is it converts this pile of papers into an entity that can own title to assets. So what occurs is you would take the deed to the house, and then you would put that title into the living trust, and then grandma or granddad or mom or dad no longer owns the house. Their trust owns the house. Therefore, they can peacefully die not having to have their estate probated because they didn't own anything that was worth $150,000. It's all in the trust. You say, whoa, that's pretty dangerous because they're going to lose control of their assets. No, not necessarily. If you look at my drawing, on the right-hand side, it says trustee you. So that's grandma and granddad. That is, they're the ones with $150,000 over their head, but they are the first trustees of their living trust, which means that as long as they're alive, they control this trust, and if they decide that they want to tear up the trust and they want that property back in their names, or if they're going to refinance the property and they have to take it out of the trust in the first place to refinance it, they can do that like the next day. It's their trust. And they don't have to give anything to the beneficiaries if they want to. They can state, I wrote all this stuff in the trust, but I'm going to cash it all in and take a trip around the world. And when I die, my beneficiaries will cry for me, but they'll cry even more because they're not going to get it. It's their asset. You have a quick question?
Yeah, there must be those people riding on the bumper sticker that says, I'm spending my children's in here.
Oh, yeah.
So it's entirely revocable.
Totally revocable. Totally revocable. As opposed to an irrevocable trust, which I argue very strenuously with my clients to not do, because you have to have a judge to agree to change this trust, and the judge wants to make sure this trust is being changed. An irrevocable trust is it's like having a loaded gun somewhere. It's a serious thing. You don't want to do that lightly. Anyway, back to my little drawing here. You would tell grandma or granddad, look, you are in charge of your own trust. You can just tear it up if you want to, whatever it is. But the good thing is that when the last of you die, your grandma and granddad or mom and dad, when the last of you dies, then these assets will flow immediately to whomever you want them to get. That is, these beneficiaries on the bottom right-hand side of this paper here, they're going to immediately get that. Why? Because in the living trust, it states, Sally gets this, Johnny gets that. This decides exactly what's supposed to occur. And you avoid the probate because mom or dad, grandma or granddad, did not own assets worth $150,000 or more. Okay. Now, what happens if the last of mom, dad, grandma, and granddad dies? Who's going to make sure that this system works? Well, underneath it, you see something that says alternate trustee. Every trust has to have someone in there who is going to be the alternate to the people who created the trust, so that they can carry out the wishes of the persons who created the trust in the first place. Now, what happens if that alternate trustee was their son, John, and John didn't like a beneficiary, Sally?
Time's up for the
15,
15.
thank you. And, you know, California, everybody's automated here, I love it. If John didn't like Sally and cheated Sally out of a quarter of what she was supposed to get, if you look at the farthest right-hand beneficiary, you'll see an arrow from that person up to the alternate trustee. That person can drag the alternate trustee into court, the very thing everybody's trying to avoid. Drag that alternate trustee into probate court, the court will have the trust spread out in front of it, and then end up giving Sally what she was supposed to get in the first place, that you, if you were the trustee, were trying to cheat her out of. That is, you can assure grandma and granddad, or mom and dad, that the whole process is self-correcting. That is, if after they're gone, their alternate trustee tries to do something different than what they want to do, then you can believe that that beneficiary is going to lawyer up, and the lawyer will present to the judge what was supposed to occur, and the judge will enforce that it does occur, even if it has to come out of the assets of the alternate trustee who was doing something wrong. Okay? Now, how much does a living trust cost? It depends on who you go to have it done. A couple $1,000. Trusts can be pretty sophisticated, or they can be pretty simple. So for one person, you might charge $1,500, $2,000. For two people, you might double that. Why? Because when you have two people, when the first dies, everything theoretically should be static. There shouldn't be any transfers of assets, because theoretically, the person who survived needs to live on those assets and live in those assets, deal with those assets. You don't want anything to disrupt that, especially as people get up in age when they're older than me. Anyway, they don't want disturbances in their lives. So the trust should be written, and there are formulaic trusts that are written this way, where when the first person dies, nothing gets changed. But when the second person dies, that's when it all starts occurring, and then your alternate trustee is the person who's supposed to carry it out.
Quick question. When the first person dies, since now you only have one beneficiary.
No, you can have 100 beneficiaries.
One person who's
One trustee.
trustee. They can change, or they can sell properties, or are you saying that in the contract you can call for it not to be changed?
Yeah, good question, and let me try to answer that.
Okay.
Whatever you wrote in your trust, the alternate trustee is charged with enforcing. If the alternate trustee is trying to change, do something different than what's in your trust, you gonna let me finish?
Sorry, I think you were mentioning the trustee. There's two people, but one of them died.
One,
They
I'm
can
talking
change.
the other one that's still.
Not the
Can the living trustee change the trust?
Yeah, the last person.
Oh, you're talking about,
Yeah, that's what he means.
okay. I thought you were talking about the alternate trustee.
No.
Okay, thanks for interrupting me. And thanks for clarifying. Yeah. No. Yes and no, it depends. See, in California, we have community property and we have separate property. So, you can come into a marriage with separate property, and that separate property, until the day you die, is not the property of your spouse, it's your separate property. There are exceptions, like suppose you didn't work like a 9-to-5 job, and all you did was work your investments. You inherited a big pile of money, and all you did was invest it in the market, etc. Well, with a proper lawsuit, the court would say that your spouse has an interest in your earnings from that investment. But let's just erase that, pretend like I didn't say that. Generally, people come into a marriage with separate property, or they, basically separate property, or they have no property at all. But all of the property that is earned and this is money that's earned or the assets that are acquired with community funds, earned during a marriage are called community property. And with community property, you generally deed that into, deed that into the trust. And then when one person dies, both husband and wife in this situation have a 50% interest in the community property. Well, the survivor can't change that asset. That is, they can't say, oh, let's do something different with this asset that both of us decided we wanted to do otherwise. Why? Because then you would be changing the wishes of the deceased person, and theoretically, and actually in the courts, when that deceased person dies, their share of the assets and their portion of the assets freezes. And it's supposed to be enforced by the alternate trustee. That is, do exactly what that says. If you try to change that, then someone's going to lawyer up. The lawyer brings it into court, and the judge says, oh, wait a second. This is community property, and though you have a 50% undivided interest in this community property, you can't affect it in a negative way to the deceased person. Hope that's clear. Okay, great. That being the case, I concluded my speech. Once again, don't applaud, just throw dollars. Are there questions?
Question.
Yes.
Going back to the first portion where you had a person had a will or may not have a will.
Oh, yeah.
The
I should
process-
talk about the will. Thank you.
Yeah, I was going to say, because I thought the will,
Let me talk about the will. Thank you. A will just states where the assets are supposed to go. But if you have a will, it still has to be probated if your assets are worth more than $150,000. Now, let's suppose that after you've done a living trust, you hit the lotto for $1 million. That you're the one who wrote the trust, and then you hit the lotto for $1 million. That $1 million is not listed in the trust. So what happens to it? I am here to say that the will that comes with every living trust is called a pour over will. P-O-U-R, pour over will. And all the assets that you own at the time you die that are not listed in the trust pour into the trust. And in the trust is a paragraph that states anything I haven't specifically given to my beneficiaries, I give to, and then you start naming the people, X, Y, Z, in these proportions. It's called a residuary clause. So that will pours everything into the trust, and that will is to gather up, to catch any assets that you have when you die that are not in the trust. Okay? Now, if you don't have a trust at all, and all you have is a will, then it's just going to be probated. So what's your question regarding a will?
that's what I thought. I thought a will was, but I didn't understand that. Over 150,000, it's mandatory that it has to be.
Yes.
That's what he said. I wasn't informed.
And we'll get you in a second. One second. Some people say to me, well, I'm just going to transfer this. I have a will, or I don't have a will. And I'm just going to tell my son or daughter or somebody like that, just transfer these assets when I die, and don't worry about probate. Well, then the bank say, well, I'm sorry, I need to have somebody with a court stamp on it before I start dealing with this money. Or the real estate people say, oh, well, we need grandma to sign this deed. You say, well, she's dead. Well, guess you got a problem there. You got a probate. So that's where it comes back. And there used to be an auto commercial that says, either see me now or see me later. So that's the same thing with probate. If you try to get around it, then pretty soon you'll find out some asset that you really want to get or you want someone to have, you're not going to get it until somebody files some paper in court for the probate. Yes, sir.
Living trust do living trusts have any effect on state tax at all? With that at all?
The trust itself, well, yes and no. You remember I was saying that when you have married couples, it gets there's a more complicated. The trust becomes more complicated. theoretically, when the first person dies, and let's say each one of them has $1 million, or the whole estate is $2 million with community property, each one is worth $1 million. Theoretically, when the first person dies, well, that won't even help, because the estate tax now triggers at $5 million. But if several years from now, you were talking, Jason, about the taxes going up. Several years from now, when they lower the level at which estate taxes have to be paid, no longer $5 million, it'll be $4 million, it'll be $1.5 million, something like that. When it gets low like that, and someone dies, then when the first person dies, theoretically a tax is supposed to be paid at the time of that person's death. Various types of trusts. That obligation to pay the tax on the death of the first person gets deferred until the second person dies. And you want to make sure that your trust is laid out that way, so that the people who are doing the trust, they can just say, hey, doesn't bother me, it'll come out of my inheritance, the people who are supposed to inherit something. As opposed to, and what they're trying to avoid is, the husband dies, and the little old lady, wife, survivor, she's got to sell the house or do something to pay off an estate tax. Well, when you do a trust correctly, it keeps that from occurring. The kids will take the hit on that. So that's one area of it. But trusts are one thing, and then the estate taxes are another thing. So, yes. Oh, wait one second. Talk to you a couple times. Yes.
So the estate tax only kicks in on an estate value of over $5 million?
Yeah, that is, the value in excess of the $5 million is what is taxed. Right.
That's in a trust.
No. That's
Either way, it doesn't matter.
Yeah, if all you have is a will.
Okay.
Yes.
Yeah, if a person has a will, or say he doesn't have a will, and an executor is not named in that will.
Well,
who
see,
determines- who
that's a
determines-
really
okay.
bad will to not have.
Okay, well, okay, say there's no will.
Okay, no.
Okay, and there's no executor. Who determines who that executor is? And the lawyer for that matter.
The courts do.
Of course you,
The
okay.
courts do. So what happens is, when someone dies and there's no will, then the beneficiaries go scurrying for attorneys. And so the first one to file doesn't necessarily get it, but the first one to file at least establishes the date for when the hearing is going to occur. And then the other beneficiaries, they come in and they object. They say, oh, that's a terrible person to be the executive. My person should be it. And then, just money is thrown all over the place. And eventually, the judge says, well, costs on all your houses. What I'm going to do is select some lawyer who practices here in front of me all the time. That person will be the administrator of the estate, and none of you guys are going to get the money. None of you get the executive's money. Okay. That's what happens all the time, because the judge doesn't know who to believe, and he really shouldn't try to believe any of these, because all of them are lying, trying to get the money. And it doesn't matter how pretty the picture you paint for the judge, because the judge really doesn't know if you're lying or not. So the judge will pick some lawyer to be the administrator of the state, and that's what's going to happen. That's why I say, be kind to the brothers and sisters, because it'll truly go elsewhere if it's not. Now the question.
If they end up selecting an attorney to be the administrator, you still need another attorney before you had an administrator and an attorney that was going through the probate. So would you have two attorneys now, because the court is appointing one as the administrator, who already has the background for doing it, so he would do one and he gets paid both sides of it, or just one?
Not necessarily.
Okay.
That attorney may have an attorney advising him or her,
Okay.
because he or she is actually acting like the normal administrator, but they have the superior knowledge because they do this stuff all the time.
Right.
But I've seen it where they have hired an attorney to deal with some issues that have arisen by the fractious brothers and sisters fighting them and everybody else, and they have to have an attorney to do that, because if they're going to be the administrator, they have to be neutral and just deal with that. So they have to have the attorney to be the bad guy. You had a question, Don.
Oh, I was just going to say, is there a living trust, is there a tax, because you're not owning the property? So when you do your taxes, how does that?
Oh, no. Those of you who are old enough to remember Prop 13, and then some of you maybe are not there. That was a joke again.
Not for the little guy.
Well, the whole guy did that. See, back before Prop 13, grandma would give the property to daughter. And when grandma bought it, the house was like $35,000. When daughter got it, it was worth $400,000, and the property taxes, boom, went up to, based on $400,000 instead of $35,000. And so that's a terrible thing. It was considered to be a terrible thing. Whenever there is a transfer of real property, there is a form that has to be filed called preliminary change of ownership statement. And what that does is lists about 20 different exceptions or exemptions from this requirement that the property be reassessed on the transfer. So if you are not related to me, transfer property to me, your basis is one thing, but my basis is going to be whatever this new thing is, and the tax is going to be on this high thing. But if you're my father and I'm your son, and you transfer the property to me, then it's a parent-to-child transfer or grandparent-to-child transfer, and that's an exception to the rule that the property is reassessed. So it doesn't have to normally.
That's fair.
Okay, thank you. Barry, sit down.
Continue with questions.
I was going to ask, so can you explain how the life insurance affects the states, especially with over the 150,000?
Well, yeah. Well, first off, life insurance is a contract.
Right.
So even if you are probating an estate, it's outside of the whole probate. It doesn't even count. So you have $5 million worth of insurance, and you say, oh my God, I have to probate. No, because that's a contract outside the whole probate system. And it just goes to whoever is the beneficiary of that contract.
Without taxation.
It might be Walmart, it might be whatever.
And that's without taxation on the $5,000 from your insurance benefits, the person receiving it, they don't pay taxes on that, do they?
I don't think they do.
it's
I
it's
can't
part
say that
of
for sure.
Yeah.
In the attorney, other attorney.
Yeah, you don't pay any income taxes, but it can be part of your estate if it's not inside the trust.
It's outside the trust, yeah.
Right.
Well, it's not probated either.
Right, but it's calculated within your trust amount, correct?
Okay.
It
Not at all.
goes into calculating the value of the gross estate. So if you have $1 million in life insurance and you have $4 million in other assets, then your gross estate value, if the deceased owned it, then the gross estate is $5 million.
Okay, there you are. That's for estate tax purposes.
Exactly.
Correct.
Okay, great. But it has nothing to do with the trust, and it's not part of probate.
That's good.
Yes.
So, you didn't say, you said a living trust is going to be $1,500 and $2,000. What about a will?
Oh, will, if there's no trust, a will is, 350, something like that.
But what if there is a trust? If you want to do a will.
Well, see, the will is part of the trust. That is, it's, the cost of the will is part of the